Mr. Bhandari, do you mean that
judgment cite kar de?
the first citation? Mr. Bhandari, do you mean that before making rules, there must be some law?
Well, I'm not saying that. There may be.
So subject to law, what does it mean, subject to law?
Well, and a validly enacted law by the appropriate legislature. It could be pre-existing. It could
without any enactment, rule cannot be made.
No, rules can be made. They can
but
be
subject to law.
My lord, the rule-making power is a standalone, independent power on the Supreme Court.
But subject to law.
If there is a law, then the Parliament can make that law within the limits that I will just explain.
You said Parliament can make a law.
Parliament can, but I will just explain what, in my humble understanding, are the limits on that. I will explain that.
But there citations there.
My lord,
Mr. Bhandari, that is subject to constitution and law. So you borrowed this power from the constitution and subsequently you made rules.
Yes, my lord.
This is the intent.
This is the intent. This is the intent. My lord, the citation is by Muhammad Khan versus Border Allotment Committee, PLD 1965, Supreme Court 623, at page 633.
For what proposition?
My lord, this expression, subject to constitution and law, was discussed in detail by Mr. Justice Kekaus in his judgment, and this was then followed in LDA versus Imrana Tivana, 2015 SCMR 1739.
एक सेकंड दूसरा कौन सा है?
2015 SCMR
अब तो दो यार
1739.
ठीक है, ये phrase discussed हुआ
है.
This phrase has been discussed.
This phrase, subject to the constitution and the law.
कैसे किस नतीजे पे पहुंचे?
And they said that it means that the power which is being made subject must be made subject to a law which is derived from some other power in the constitution.
ठीक.
So that's my submission, that when it says subject to the law in Article 191, in order to know what law can be made under in this context, you will have to go to other provisions of the constitution.
The relevant page बता दीजिए उसका कौन सा judgment है?
Well, at 65 Supreme Court 623 at 633.
633 और दूसरे वाले का?
And Imrana Tivana का है जी 2015 SCMR 1739, paras 51 to 53 at 1764 1765.
Law Development Authority over Tivana.
इस वाली लॉ की सोर्स पर क्या? Go ahead.
इसकी. So this by itself, I say. So you go back to 142, and there is no other provision in the body of the Constitution dealing with this. So my lord, you go back to 142. 142 takes you to entry 55. So let us see whether there is any
Entry
part.
55 is only related to the jurisdiction part.
My lord, it will also cover practice and procedure. Just let me explain why.
It is only related to the subject to the constitution.
My lord, what?
ये जो आप अभी बता रहे हैं ना, इसमें तो subject to the constitution है, and law के ऊपर नहीं है, इसके ऊपर आप जो definition बता रहे हैं.
Kekaus साहब ने specifically subject to constitution and law भी discuss किया.
Judgment है ना, ये LDA का जो judgment है इमरान टिवाना का.
नहीं सर, आप Kekaus वाला देखिए. Kekaus साहब की.
52, the only word subject to the constitution.
No sir, ये जो 65 Supreme Court है, उसमें दोनों डिस्कस.
It is referring the article 142. उसमें तो शब्द लफ्ज़ ही शुरू में
वो
introductory है.
तो सब्जेक्ट
तो बताया subject to constitution.
जी, बट जो 65 सुप्रीम कोर्ट है, उसमें ये उन्होंने सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ दोनों को डिस्कस किया है.
इसका जो 65 का कौन सा पेज?
623 at 633.
जरा इसको पढ़ लें.
65 अगर आप देखें सर.
Yes.
जी, my lord, at 633.
ये भी subject to this constitution ही है, law नहीं है इसके अंदर.
तो है. जी आप देख लें.
पेज आप बता रहे हैं उसमें तो नहीं मिल रहा है.
जी ये आप यहाँ से
You are referring page 633.
ये सर मैं नीचे से 11th 12th line from the bottom at 633. The central legislature can legislate with respect to jurisdiction of courts, but the jurisdiction granted by Article 98 is subject only to this constitution and not to this constitution and the law. a reference
So
to the
ये तो
various provisions of
then my lord is correct.
My lord, आगे देख लेते हैं.
अजी अच्छा.
A reference to the various provisions of the Constitution will show that whenever it uses only the word subject to this Constitution, it does not mean subject to this Constitution and the law. But whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution, the Constitution says so. So, when Constitution and the law...
So what? I'm not following.
Well, what it is saying is...
वो जो आपकी, don't use your own words, use the words of the judgment.
This is that whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution.
It's not
begs the
enabling, it's
question.
not a power that is giving legislative competence.
Yes, that's what I'm saying, that
You have to go
then
back looking for the competence.
Yes, you have to go to the source of the power in the Constitution. And there the source of the power has to be in some other provision of the Constitution, which takes you to 142, and 142 takes you to entry
Fair enough,
55.
but that's not coming out of this judgment.
Well, that is the only judgment on this that I...
No, but this...
ठीक है, आपने मेहनत की, that's good.
But this is how I read this passage. Then let's go to entry 55.
You say that that law under 191 would stand through 55?
It can only stand through 55.
Only through 55.
Only through 55. Your
But
lordship has-
एक second ठहर जाइए. Why not 55 read with 59?
But these are 59.
No, the 59 भी पढ़ लेना.
59 relates to matters incidental or ancillary to any matter enumerated in this part.
So it may not, देखिए जरा सा, my understanding is I may be subject to correction. It may not specifically be mentioned there, but it can expand. If otherwise 59 is redundant, so then ancillary matters, incidental or ancillary matters can be added on to. So every provision, every item should be read with 59.
Absolutely.
ठीक है. अच्छा,
Absolutely.
एक second. Incidentally, you mentioned privacy, and I was just going through the list. I don't come across that word in the fourth schedule. Please correct me if I'm wrong.
Well,
You said the Federation can make law, you started with Article 14 and privacy you mentioned.
My lord.
But the cursory examination of the fourth schedule does not throw up the word privacy.
It doesn't, my lord, but there are...
No, but you said then both the Federation can make laws.
And it has.
No, it has. Can it still be unconstitutional? But in the argument, you should forget if it has. This they have also made a law, so that's neither is here nor there. But if the word is not mentioned, then your argument should have been that only the province can make the law.
Well,
Please enlighten me.
My lord, the parliament has, for example,
ये example यही ले लेना.
legislative competence to enact laws about companies. Now, in exercise about companies.
No,
entry 31.
Bandari sir, no, please don't do this.
Let me-
No, don't do this.
Make an argument.
No, you use the word, you chose the word of all the thousands of words circulating in the universe, privacy. You chose Article 14. Either you take back that argument or entrench that argument with legal argument.
That's what I'm trying to do.
आप companies पे चले गए.
मैं company से example आपको समझाऊंगा जी.
Learned counsel,
Company, let me
इसको
answer.
मैं जरा
Let me answer this question.
इसको formulate कर दो. आपने जिस तरह कहा कि कानून बनाने का इख्तियार है आर्टिकल 14 है इसमें, regardless of and notwithstanding Article 191, say a law is validly and competently made by the legislature. What if that law is in conflict with the rules made by the Supreme Court under Article 191? How will you read subject to law? Will the rules prevail or that law?
I will come to that, but let me answer my Lord the Chief Justice's question. My Lord, in exercise of power granted by entry 31, the company law is there. Now, the company law contains elaborate provisions which deal with the question of privacy of businesses, their premises. It deals with when search and seizure can be made, if documents can be...
Take the point.
So, similarly, because criminal law is on the concurrent list under entry 1.
You make the point about privacy.
Therefore, province has also made laws which affect the concept of privacy.
Sahab.
Privacy alone, privacy can very well be a standalone subject matter of a statute. It is a concept
यही तो
which
पूछ रहे हैं, federal or provincial?
both. It can,
Okay,
you
ठीक
made
है.
your,
You made your point. If you could come back to
It
the,
can be both.
you made your point.
My lord.
We've noted your
My
point.
lord,
If you
I
could come back to entry 55.
Entry 55. Let's read it, my lord. Jurisdiction, and it has two parts. The first part, and my lord, what the Honorable Chief Justice said about entry 59 is exactly my case, and I'll explain why. The first part of entry 55, jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list. So this doesn't apply to the Supreme Court.
आगे चलो.
And to such extent as is expressly authorized by or under the Constitution, the enlargement of the jurisdiction of the Supreme Court and conferring thereon of supplemental powers. Once this is invoked, then, as my Lord the Chief Justice said, matters ancillary or incidental or ancillary to any matter can also be brought in. Now, what does this expression mean? Entry 55, there can only be enlargement of jurisdiction, but only where there is an express authorization by or under the Constitution.
But you're missing out the earlier words, as is expressly authorized by or under the Constitution.
Yes.
No, just wait a minute.
Well,
Where is 184.3 expressly authorized?
it is not.
It is. 184.3 is in the Constitution.
But there is.
You're not hearing the point.